when we started setting up this conference, I thought I wanted to do something on sentencing. The difficulty I had, however, was that I didn't know too much about it, which I think is a ringing endorsement of how great my presentation is about to be. But what I did know was that the UN Security Council did not provide the ICTR with much guidance when it came to sentencing. So anybody familiar with this issue is that the ICTR statute merely states 3 factors that the court must have regard to, but I think as the jurisprudence of the ICTR reveals, I think the court had some difficulty in giving concrete effects to those provisions. So initially what I had in mind was I wanted to conduct a study using the ICTR as a case study to look at the advantages and disadvantages associated with giving ad hoc international tribunals, let's rather say international criminal tribunals, with such an unfettered discretion to determine sentencing. So theoretically, I think we can all come to the same conclusion that the possible advantage of this is, given that at the time the ICTR and ICTY was created, the international community had not really thought about these aspects, had not negotiated a significantly comprehensive position on sentencing. It was perhaps easier, also given the time constraints, easier to defer this obligation or this responsibility to the tribunal judges, for them to either develop in their rules of procedure, as we all know that they had the power to do their own rules of procedure, or perhaps maybe in a more incremental way in their jurisprudence, to come up with a more comprehensive and consistent approach to sentencing. So with that in mind, I started looking at the literature, and for the most part, that advantage never really materialized in the judgments. And also, if you start looking at the scholarship out there, it's quite clear that commentators haven't been particularly kind to the ICTR when it comes to sentencing. So there's allegations that there's a lot of unfairness and inconsistency between sentences, the sentencing framework is unprincipled, and that so those are the concerns. So I started also trying to see if there is a lot of scholarship, perhaps other scholarship, that tries to defend what the ICTR did. That search was in vain, and I stopped it when I actually came across an article written by a former ICTR judge. I think she also served in the appeals chamber, Judge Ines Monica Weinberg-Dorocca. Hopefully I haven't butchered the name. And in her article, so obviously writing extrajudicially, but she says, consistency in sentencing has thus far eluded the accomplishments of both tribunals. Substantial discrepancies in the punishment of persons convicted of similar crimes are commonplace. One would think that if this is a concern, you would try and move towards a more comprehensive framework for trying to eliminate discrepancies. And I think it also has to be acknowledged that the ICTR judges, once again, either in their case law or in extrajudicial writing, actually talk about the fact that they acknowledge the fact that their legitimacy is dependent on the fact that they deliver consistent sentences. It's a hallmark of any contemporary criminal justice system. So my research question then changed a bit. Given the fact that they acknowledge these concerns, and given the fact that we don't really have a comprehensive sentencing framework at the ICTR, why is there a resistance on the part of ICTR judges to actually constructively engage with this issue and hope perhaps develop more of a framework? So this is where my paper lies. So I'm trying to look for the reasons and trying to perhaps hypothesize on for the reasons for this. And what I think I try to identify is that I think the ICTR was facing a dilemma that was incapable of a perfect solution. And it comes down to legitimacy. So given the fact that the ICTR wasn't given a workable framework, I think they had 2 choices. On the one hand, they could say, well, since the statute doesn't give us much guidance, we have an almost unfettered discretion to determine sentences, and we'll look at the specific cases, the specific context and facts of every specific case to derive at a sentence. The other option is, of course, from the outset to develop a very comprehensive, coherent and consistent, tries to get consistency, to try and get that framework. So as I already pointed out, the ICTR went for the more unfettered discretion, individualization approach. And as we saw, as we saw in the literature, that undermined the legitimacy of the tribunal in the sense that that approach resulted in very inconsistent sentencing, or at least to some extent. But what is the alternative, right? So if they had to develop a more comprehensive framework, that would have probably also started eroding at the legitimacy of the tribunal. And there's two things I think in particular that is notable. So what would have happened, firstly, I think there would have been allegations that the tribunal is infringing on state sovereignty. So I think we all assume that it's for the domain of the international community to negotiate how international perpetrators should be sentenced. The international community has eluded the international community, but nonetheless, it's still what we perceive. We still perceive it as the responsibility of the international community to do. But perhaps more importantly, I think it would have also infringed the rights of the accused. So the idea that judges would now prescribe laws and, more importantly, apply it with retrospective effect, I think would have also raised many legitimacy concerns. So that's the type of theory that I'm working with. Regardless of which choice they chose, there was going to be an erosion from the legitimacy of the tribunal. What I also identify is that this dilemma faced by the ICTR wasn't made any easier by the international community. And I think there was contestation on 2 points that I quickly want to bring to your attention. So firstly, in terms of the institutional role and powers of the ICTR. At the time the ICTR was created at the Security Council, I think it was Argentina that stated that the ICTR only has the powers to implement or apply existing customary international law. It doesn't have the powers to create law. On the other hand, however, respectful adherence to that was not possible. Particularly when we looked at procedure, evidence, of which I would include sentencing part of it, right? As I said, at the time of the ICTR, there wasn't any sentencing code available. So that, I think, is one dilemma that the ICTR was faced with. So it was this conflicting dual role that the Security Council gave it. The other one is also in terms of the mandate. So I think particularly yesterday we had a lot of discussion about what is the exact purpose of the ICTR. We can all agree that it's to convict and punish. But in terms of punishing, what are the objectives that we strive towards? So is it retribution? Is it deterrence? And let me just, by way of example, go back onto that reconciliation that came up quite a bit yesterday. So Russia, and I think it was Oman, said the ICTR has to contribute to national reconciliation. Where I think on the exact same page, Chile said the ICTR is hardly an institution designed to facilitate reconciliation. And I think Mark Jumble also, in his work, in his book, I think also picks up how this conflicting mandate, or this not clear enough mandate, also distilled into the jurisprudence of the ICTR. So I think he said that he picked up on some judgments indicating that retribution is the most prominent feature in sentencing. Others said deterrence is, whereas others said it was both deterrence and retribution. So once again, I think the international community hasn't spoken clearly enough on what we expect from ad hoc tribunals, and I think that obviously translates into the confusion that persists in the sentencing jurisprudence. I've also picked up 3 practices in the ICTR, also the ICTY, that I think further entrench this idea that the judges were generally reluctant to actually engage these issues. So the first one is that there was no distinct sentencing phase. Initially that was the case, so Akiyesu there was a verdict stage, and then afterwards they moved to the sentencing stage. I think in 1998 that rule was amended, and now prosecution and defense have to lead evidence during the verdict stage, the guilt stage of the trial, in terms of sentencing, which is quite, it's a bit unusual in the sense that firstly now you've got defense who have to present mitigating circumstances to crimes they deny committing. But also, I think importantly, it takes emphasis away from the importance of sentencing and the constructive engagement that process allows for the judicial development of sentencing law. So I think there was a study done, and they suggested that 0.1% of the courtroom time actually gets allocated to sentencing. The second one is, I think we're all familiar that the appeals chamber gave an almost unfettered discretion to each of the trial chambers to tailor appropriate sentences. The appeals chamber hardly overturned a sentence, and even when discrepancies started occurring between different trial chambers, the appeals chamber didn't intervene. And I don't have time to go into it, but I will make my paper available if you want it. And I point out some of those discrepancies that the appeals chamber recognized but said, we're not going to do anything about it. But I think importantly, the fact that the appeals chamber didn't intervene meant that the most authoritative body didn't get an opportunity to provide coherent and useful sentencing guidelines to the trial chambers to use. And then the last thing also is the global sentence. So it's this idea of the totality principle. What the trial chambers are permitted to impose one sentence for a multiplicity of convictions. And of course that makes it incredibly difficult to start comparing cases when we don't really understand the rationales and justifications for imposing a particular sentence for a particular crime. So what do I say is the lesson learned from the ICTR in terms of sentencing is that owing to the competing legitimacy concerns that come as a result of giving this almost unfettered discretion to the ICTR judges, I suggest that international criminal judges are ill-placed to develop sentencing laws, and particularly when I think the foundational framework provided by states is actually not clear and contested. And I argue that it is the responsibility of the international community to provide these sentencing guidelines, and it's not something that should be easily delegated to judges. And this is important if we are concerned with the legitimacy of the tribunal itself, but also international criminal justice as a whole. Thank you.